Supplementary list, pronouncement of judgment, item number 1.
On another aspect, the case put up by the state respondents cannot be ignored, as a stand taken by them supported by credible documentation and evidence. This observation is made in view of the fact that the lease document made in favor of the then British government in 1874 of lands which include land in question has not been rebutted or any material produced to the contrary. In fact, respondent number 10 also claims the same lands question has also annexed the lease documents in her affidavit. Another aspect which is equally important is that entire episode with regard to purported transaction and sale of the land between respondent 11 and writ petitioner and subsequent offer to sell to Air Force authorities, as also the other collateral proceedings before the same William and District Council courts, were not to the knowledge of state respondents who appear to have been kept in the dark. As narrated on affidavit by state respondents, only after the offer was made to Air Force authorities that matter came to light and steps were initiated to redeem the situation. Coming back to a grievance writ petitioner that he was not heard or afforded adequate opportunity, the materials produced by the parties and his own admission speak otherwise. It is noted that he was served with notice to appear for respondent number 7 and declined to do so, refused notice to appear for respondent number 8, and in spite of service of notice, failed to appear in inquiry conducted by state respondents to ascertain and verify the location of the land in question. Though the proceedings for respondent number 7 and 8 now seem inconsequential, into the larger picture with the entrance state respondents into the arena, the case of petitioner that he was not heard apart from losing any importance is also incorrect, as he was issued notice and his non-participation can squarely be attributed to his own laches. For the aforementioned reasons, the petition being devoid of any merits are dismissed.
Apply, Your Lordship.
Item number 2.
Lordship.
Who use it? The relationship of the parties, it is noted, is governed purely by a contract and the terms contained therein, which was entered into by the petitioner respondent number 287/2021. A perusal of the terms and conditions and the agreement dated so-and-so leaves no room for doubt that the petitioner agreed and undertaken to perform and fulfill all the operations and obligations for the execution of said contract as per the terms and conditions contained therein. The terms and conditions contained said documents all clearly provide details such as scope of works, commencement, period allowed for completion of contract, jurisdiction with regard to disputes, if any, and also for penalty of liquidated damages if the progress of work not found satisfactory. As the relationship is governed purely in terms of the contract discussed above, in such cases, contractual obligations are therefore matters of private law, and a writ would not lie to enforce any civil liability arising out of such contracts. The instant case is also not a case of enforcement of statutory contract just because it is for construction of public utility, as can be discerned from the terms and conditions of the contract. Without referring to any particular decision, but from the various judgments of the Honorable Supreme Court down the years, the law is well settled that in pure contractual matters, extraordinary jurisdiction under 226 not invoked unless exceptional circumstances are present, which might come into the realm of public law, which is clear in the situation in the present case. The writ petitioners also raised questions of disputed facts in the forms of bills which have been claimed, which yet to be verified, and subject to the extent of work completed, which disputes form the basis of termination of the contract. The correctness of termination, therefore, having to be adjudged against these factors, the dispute cannot be resolved executed writ proceedings such as the present one. On the other aspect, this court finds for submission of respondents that writ petition's unsustainable merits as relief of specific performance is being sought after termination of the agreement, apart from petitioner seeking extension of stipulated time for execution of the contract as will amount to altering the terms thereof. The allegation of petitioner that termination orders non-speaking and that adequate opportunity was not afforded before terminating the contract deserves no consideration, as the petitioner has not demonstrated any enforceable right or any violation thereof to warrant any interference. without delving into other contentions and events that have been put forward by the respondents, such as the charges of corrupt practices in institutional criminal cases, and other documents illustrating the breach of agreement and the default of the petitioner in the execution of the contract, this petition fails on the ground of maintainability itself, is dismissed. Yes.
Any mention?
Yes. Yes, I mentioned. Mr. Counsel, what's your name?
Item number 3.
Soman Chaudhary. Yes, Chaudhary.
You are mentioning any matter?
I have a case listed.
Well, then sit down. Yes.
May I please, Your Lordship, I beg to mention item number 19, Your Lordship. Let this matter be taken after 2 weeks. Item number 19.
9 from the main list. 19. 19. Fleming B. Marak.
Yes, Your Lordship.
SD is on sanction leave.
Yes, Your Lordship.
How long?
2 weeks, Your Lordship.
2 weeks. 2 weeks. Yes.
Mr. Your Lordship.
May I see?
Your Lordship,
Yes,
I beg to mention item number 23
On behalf of?
on behalf of the petitioner. 2 weeks' time will be granted.
Why? No reason.
Your Lordship, I would like to mention an unlisted matter. The urgency of the case is that the Secretary of MUDA issued a notification for enhancement of rents from 60 to 70%. So we are highly aggrieved by this notification. Can this matter be listed on Monday?
Yes, hello.
Please, Your Lordship. Your Lordship, I beg to mention number item 24.
20?
24, Your Lordship. And for the respondent number 5.
24?
24, yes, Your Lordship.
No objection, Your Lordship.
Why?
Mr. Pubin is out of station, Your Lordship.
This is after 2 weeks as Mr. Cuban. Arguing counsel for respondent number?
Respondent number 5, Your Lordship.
Let it be out of station, yes. Yes.
Hello.
Lordship, here I am appearing on behalf of State Respondent Hazarika, A.S. Hazarika, Lordship. He is out of the station. 1 to 4, Lordship.
No need to record. He's not there. No problem. Yes, Cuban is not there. Follow up the case.
Supplementary list, item number 3.
Your Lordship, I beg to mention item number 22. Your Lordship, the conducting counsel, Ms. R. Colney, Your Lordship, is not available today.
Yes, 2 weeks.
Obliged, Your Lordship. A similar prayer, Your Lordship, for item number 20. Mr. H. Hazarika is not available today, Your
Yes.
Lordship.
Anything else?
Beg to mention item number 18, Lordship.
Amina Khatun.
Yes, I am difficult to tell, Lordship. 2 weeks,
Yes.
Lordship.
That's it.
Lordship,
Yes.
WPC number 104 of 2023. This
Samrat in the here.
yes, is Union of India.
They have not served the copy, my lord. My name is shown in the copy.
Serve copy first. When do you want it listed?
Copy was served yesterday.
I don't know. He's not got a copy. When do you want it? After 1 week?
No, my lord, there is a stay matter. Copy was served.
I don't know about that. If the DSS copy is not served, not served. I take the submissions of the advocates at the bar and accept them. You fix it up among yourselves. They'll give a date.
Main list,
Next item.
item number 1.
Who's the local counsel?
Yes. Yes.
No, I don't want the name. You have a local counsel?
Yes.
Very good. Yes.
Petition, my lord, Mr. Abraham is on the other side. Mr. Abraham is on the other side.
He's not well. Who's appearing on behalf of Mr. Abraham? Is he come to court?
I did not see him.
Your Lordship, he is out of station, Your Lordship.
As Mr. Abraham on behalf of the state respondent not available. This matter after 1 week.
Much obliged.
Item number 2.
My lord, an affidavit has been filed by where the report says that it is delivered, my lord.
8 and 10.
Yes, my lord.
Yeah, Mr. Where's the factum of service?
My lord, it's in page 8, my lord.
Page 8 of
The
your service
report.
affidavit.
Yes, my lord.
You file a service affidavit?
Yes, my lord.
Okay. Page
8, Annex 3.
Yes, Mr. Alja submits that response of 8 and 10 has since been served and affidavit of service has been filed in this regard. We'll give them 1 day to appear. It's a list matter after 2 weeks to enable appearance for number, response number 8 and 10.
3. 3.
Mr. Vora is on leave, I think.
Just have a check. No, my lord, it's not indicated.
No one on his behalf. What to do? None appear on behalf of the petitioner. List after 2 weeks.
4.
Why was there no appearance on the last occasion by both the parties?
Your Lordship, we rely on the date of the CIS, but it was given a wrong date.
Very bad.
We apologize for that, Your Honor. Lord.
What is the reason for non-appearance on that day also? Even for this court didn't appear before that court, also you filed for extension of time for Banner statement, he didn't appear.
My Lord, by the time we had appeared again, the order was passed, my Lord.
So what to do?
My Lord, we are seeking some time to file a written statement.
Let them reconsider.
Yes.
Right, Mr. N. Kherayua, Mr.
My Lord,
Oshila. Oshila, Your Lordship.
Mr. Oshila for the respondent. So,
my Lord, M. Sharma, my Lord, not M. Khera.
oh, I'm sorry. I'm with my niece, M. Sharma. Mr. Manoj Sharma. Yes, sir. So the case of the petitioner is the prayer of the petitioner necessary review application is for allowing the petitioner. No, not that. Stop me. The grievance of the writ petitioner, not prayer, is that by the impugn order dated 15/11/2022, the filing of written statement has been closed by the trial court. Next paragraph, Mr. M. Sharma submits that as the written statement had not been filed within the statutory period fixed under Order 8 Rule 1, an application for grant of more time was filed, being petition number 51 of 2022. But however, though the counsel is present, before the same could be moved, the impugn order had already been passed. So, that counsel prays that as the laches occurred due to the delay in appearance of the counsel, the same be condoned and they be allowed to move the application which is already on record before the trial court. So, Mr. Oshala,
Yes, Your Lordship.
for the respondent fairly concedes a submission that the Fairly concedes the submission. Any other submission you have?
Yes, Your Lordship, there's a need to expedite the...
Yes, fairly good submission,
considering
but
the
has also made a prayer that in the event the matter is allowed, the trial court should expedite the hearing of the case. So having heard the counsel of the parties on this limited point only, this written application is allowed. And the impugn order dated 10, impugn order dated
15 November.
Dated
15 November.
No, to get the correct date. It's
15 November, Your Lordship.
It's not given here. Which date is it?
15, my lord.
15 November.
2022, my lord.
15?
November. 15/11/2022, my lord.
Stop now. And unlimited, huh? (11 2022) is hereby quashed and set aside, and the petition number 51 of 2022
51 of 2022, my lord.
is restored to file. Stop. It is made clear that the matter shall be taken up for disposal expeditiously, as also the main suit. So, with the above noted directions, the matter stands disposal.
Deeply obliged.
5.
May please, Your Lordship. Lordship, may please to grant 1 week time to file my rejoinder.
How many times you asked?
Yes, Your Lordship, the rejoinder is in fact complete already, Your Lordship.
No, how many times you asked?
3 times, I think, Your Lordship.
No, this is a matter for hearing.
Kindly give me 1 week time. It's ready, Your Lordship.
This is a matter for hearing. The petitioner may file the Ms. Williams also. The petitioner may file the rejoinder before the hearing date. You file it for the hearing date.
6. Much obliged.
Good copies it other side.
Yes, Your Lordship.
May I please, Your Lordship? Your Lordship, we could not complete instruction, Your Lordship. Let this matter come up of Tuesday.
It's been complied, you said, no?
Your Lordship, Ms. R. Colney is not here today, Your Lordship.
As MS Colney is not present, and this is a matter of 1 week. So also to enable the petitioner to obtain instructions.
Much obliged, Your Lordship.
Obliged, Lordship.
7.
Please, Lordship. I have contacted the petitioner. Actually, they are under process. Actually, that petitioner is one of the petitioner is sick. He went to Garo Hills, and he's here in Parapani. I even contacted the private respondent also. They are yet to settle the matter, Lordship. Only kindly maybe 2 weeks time may be given because they are very, very far. One private respondent is from Garo Hills. 2 of them are.
You have not established even your right also. What is the first right you have?
No, I will establish, Lordship, because if they fail to settle, then I will definitely file my this one rejoinder, Lordship. I'll to bring on record how that's now. But now,
Sama pre-response allowed 1 week for that time to obtain necessary instructions.
Lordship.
On the settlement.
Lordship.
8.
Lordship.
8.
Your Lordship, I've already served a copy, Your Lordship. I'll be filing the course of the day, Your Lordship.
MS Ailingwa, GF for 123, submits that the affidavit be filed in the course of the day. Respondent number 4, anybody appearing?
No appearing, Lordship, because
as no one appears, number 4, as per the last order, the matter shall henceforth proceed ex parte and said respondent.
Obliged,
Yes.
9.
May it please Your Lordship. Lordship, so far as state is concerned, Lordship, if it will be filed in the course of the day, Lordship.
M. Sumer, 5 to 7, 10 to 13. Who's M. Sumer? Mr. M. Sumer, whom? 8, 9, 14.
State is filing, Your Lordship, in the course of
Mr. Andy, should I let AG with so submits that the affidavit we have response 1 to 4 we file in the course of the day. None appears response 5 to 7 and 10 to 13. Stop. It's also noted that the AD card on behalf of 8 and 9 is yet to be received. That's after 2 weeks.
Obliged.
For the order, please.
10.
Please, Your Lordship. Your Lordship will require some more time, Your Lordship, for the instructions for this matter, Your Lordship, regarding the.
You've been waiting for so long.
Yes, Your Lordship.
Also
They
filed
filed
an
the
affidavit.
rejoinder.
Bringing
Then?
on record the representation. Lordship.
Positive instructions.
Yes, Your Lordship.
Yeah.
The representation you brought it on record by way
I
of
filed, Your Lordship.
When was
yesterday.
that?
Yesterday, Your Lordship. We filed.
Let's see that. Yes. Lecture 2.
Next. Yes, Your Lordship.
What are you saying, Muzaffar?
Yes, Your Lordship. Your Lordship, we still require more time, Your Lordship.
How more time? Because see, last time you've taken enough time.
Lordship, actually what happened is that on the last day, the learned senior for the respondents had submitted that the act is retrospective, but it is not, Your Lordship.
It's not.
If you would come to page 20 of the writ petition, Your Lordship.
20.
20, Your Lordship. And extra 2.
You don't have the file also?
No, Your Lordship.
Very good. You can share her file.
Your Lordship, it's okay.
Oh, it's okay.
No, Your Lordship.
Right.
Like,
Fine.
I'll note it down.
Yes.
Your Lordship, if it come to section 1,
Yes.
subclause B,
Yes.
it's written, it shall deem to have come into force with effect from the date of publication of the results of the general election to
Okay.
the from 15 March,
March
1999.
So it's
And
prospective.
Thereafter, Your Lordship, we have
And it's
taken
only 5 pension payable is only 5,000 per month.
5,000 per month. And if it's more than one term, it's 5,800. And Lordship, the petitioners have also taken the liberty of filing an RTI since they have stated that there's no funds may be allowed to place.
Then Mr. Kantakam, they will pass orders.
Yes, Your Lordship. Your Lordship, actually, they've been
Only
sitting.
the thing is that Mr. Kanta said he's supposed to get instructions on financial implications.
Yes, Your Lordship. Your Lordship, we're still waiting on that, Your Lordship. They've been.
Where's the
Lordship,
pension?
There's no
Head for pension.
allotment. They just get a lump sum, Your Lordship. And in a year, the district council is getting 40 crores.
For pension?
No, Your Lordship. Funds, they come as a whole. There's no different heads.
We take it back now. MSc Noklau expresses a difficulty due to absence of a senior who is supposed to obtain instructions.
Lordship, kindly fix
It is
the
noted
matter
that
after-
the affidavit.
Lordship, if this
affidavit- Yes?
after a week, Your Lordship.
Your Lordship,
It's
actually,
small
we
matter.
require.
Bring a record representation as.
Your Lordship, we require more time, Your Lordship. Your Lordship, we need at least like 3 weeks, Your Lordship.
No, you only have to do arithmetic, that's all. You have to go and see how many members, multiply by 5, how many 2 terms. If more than one term, 5,800. If one term, 5,000, that's it. This is the amount will be have to be paid. And what is the arrears? And if this amount money we have.
Your Lordship, they are trying, Your Lordship, to come into a.
Simple as that. See, the right, it's not they don't have a right. She's shown that
Yes, Your Lordship.
it is applicable from 15 March 1989.
Yes, Your Lordship.
So it's prospective.
Yes, Your Lordship.
So there's nothing to adjudicate also. It's only for you to do arithmetic.
Your Lordship, they don't need much time also. They just
You
have
don't
to.
need to do arithmetic.
Your
Just a
Lordship,
matter after 1 week.
Your Lordship, can we just get at least 2 weeks, Your Lordship?
Okay, since you're praying for 2 weeks time to obtain final instructions.
11. 11.
It's all right. Counsel for the petitioner is absent. Officer indicates that after the matter was moved on 13/4/2023, no steps have also been taken. Just after 2 weeks.
12.
Your Lordship, I'm appearing on behalf of Mr. SN for respondents 2 and 3. Your Lordship, affidavit has been filed, Your Lordship.
It's been filed.
Yes, Your Lordship.
MSZ inquiry submits that on behalf of respondents 2 and 3 has been filed. What of 1? Mr. Kivarshi submits that as states a foreign party, no affidavit forthcoming. Stop. This after 2 weeks. Noted that none appears for the petitioner. I thought I don't know none appears for the petitioner. Oh, sure. So MSZ inquiry submits that. So no affidavit here.
13.
Obliged, Your Lordship.
Lordship, here the respondent number 4 has to file their affidavit.
Who's number 4? Dr. Mozika, you entered appearance last date. Is Ahimsa or
Ashima?
Ashima.
But we are also praying for time, my lord. We are also.
What's the matter about?
Lordship, this is regarding non-payment of outstanding dues.
With regard to?
Regarding construction of a high-level bridge.
Yes, Dr. Mozika. Mr. B. Barshal here, EAG, so and so for 1, 1, 2, 3. Dr. Mozika for number 4, 3, 4 on a road. 3 weeks for a time for affidavit.
14.
Hearing now.
Lordship, I need some more time, Lordship.
Of course, already shifted now.
Lordship, yes, Lordship, but it is means it is office internal matter because the project there is Nidhi Aapke Nikat is going on within for the month.
What's going on?
Nidhi Aapke Nikat means the officers of the organization needs to visit the office, so and the laborers. So they are all in.
And the laborers?
Yes, laborers of the.
What do you mean for? Yes, okay.
So laborers.
Yes.
Lordship, if I may.
Yes.
Lordship, we are an institution of repute, and Lordship, we have got our writ also. It reads that we have got no problems if we have to pay the money. All we have been requesting them is to give us the documents to justify the amount. We are not a profit-making institution, Lordship.
No, what they're saying is that the office is in disarray. They can't locate the papers also. Some substance. That's your submission, correct?
Yes.
Yes. Ms. MSP Varasi praise was allowed 2 weeks further time to file affidavit. Yes. Just thereafter.
15.
Obliged, Lordship.
15.
Lordship, I'm entering appearance on behalf of respondent 4 to 8.
Number?
4 to 8.
Number?
Respondent 4 to 8.
4 to 8. And MS Raji?
1 to 3.
1, 2, 3. What? 1, 2, 3. 4 to 8. 4 to 8 is whom? What's the matter about?
This is a cancellation of Pata, Your Lordship, without providing me.
Yes, sir. MS E1 Yang, correct?
Yes, Your Lordship.
Has entered appearance today on behalf of respondents number 4 to 8. So such a service complete. You need time to file affidavit?
Yes.
No.
Yes, Your Lordship.
MS Anraji in behalf of 1, 2, 3. That's also MS Iwana in prayer for allowed 3 weeks time to file affidavit.
May please.
Interim order passed earlier shall continue.
Right.
Until next date, yes.
Hearing 16.
Who's appearing? You ready?
Yes, Lordship.
Yes, Mr. Nokram. Please, Shandit.
May it please your Lordship.
Yes.
The petitioner has passed the degree of the Bachelor of Prosthetics and Orthotics in the year 2009 from the National Institute of Orthopedically Handicapped, Kolkata, on the West Bengal, Lordship. Lordship, after she has passed this degree, the MPSC on 26 June 2012 has advertised for this post, Lordship, for the post of prosthetics and orthotist under Health Department.
Where is that? Where is that? Which annexure? Excuse me. Weather's like that. The weather is like that. Sorry. Where's which annexure, Mr. Nokram?
Lordship, after she has passed.
Which annexure was she appointed?
She was appointed in
annexure number?
Annexure 2, Lordship. Page 12.
May I please watch appointment order would be annexure 3.
Yeah, Lordship,
Page
sorry,
number 14.
Annexure 3, Lordship, sorry.
Prosthesis and orthosis.
Yes, Lordship.
What is a sanction posed by its own. So, after selection, no, we're going to be okay. Fine. That was she was appointed on 24/5, annexure 3.
24/5/2013, Lordship.
24/5/13. Yes.
Lordship, the petitioner has never applied for any other post except for this very post which has been advertised by the MPSC, Lordship.
And she was appointed against this post only.
Lordship.
And she was appointed against this post only.
Yes,
The
Lordship.
prosthesis and orthosis, yes. This is number 6.
Lordship, as per the advertisement,
Yes.
the scale of pay was 14,100.
Okay.
But when she was appointed, Lordship, her pay was changed from 14,100 to 11,300.
Okay. After she was appointed?
After she has been appointed.
11,000?
To 11,300, Lordship.
Okay.
So thereafter she has submitted representations.
But that's from the date of 2013 only, when she's appointed, first appointment. She's appointed a scale of 11,300.
Yes, Lordship.
Okay. Then what do you do after that?
Thereafter she has submitted her representation, and then Lordship, annexure 5, as per annexure 5, page 17, as her scale of pay has been changed. So after submitting the representation,
corrected it.
Yes, correction number has been, as per annexure 5, Lordship, annexure 5, page 17.
Yes.
I'll just read a minute. The scale of pay as appearing in the directory letters and so dated 24/5/2013 may be read as 14,500.
14,100.
14,100 plus or instead of 11,000.
Right.
100.
Okay. So your prayer was answered by the corrigendum.
Yes, Lordship.
Then?
But again, after this.
Then that time you're enjoying this new scale of pay till how many years?
It's more than
5 years.
5 years. Lordship.
Okay. Then?
And then suddenly on the 28th September 2018, the impeach order was passed, Lordship, directing the petitioner to refund the excess amount paid to her. This is after a gap of more than 5 years, Lordship. Annexure 6 page.
Just read it.
Annexure 6, yeah. Page 17. Should I read, Lordship?
Yes.
From Dr. So-and-so to the petitioner. refund of excess amount of pay drawn, as informed by the Director of Health Services, MI Meghalaya Shillong, via letter so and so dated such and such dated 14/9/2018. I am to inform you that you are drawing the scale pay of rupees 14,100.
Yeah, okay. Become the joining till date as
yes,
per the corrigendum.
Yes,
dated 26/8/2013 that you've shown from the Director of Health Services, Meghalaya Shillong, which is not the scale of pay for the post of processes and authorises.
Yes.
As corrected by Director Company. Where's that correction? 9/2/12?
9/2/12, sure.
Where's the correction? You have that in your petition?
I don't have that correction, Monsieur.
The first, we have that, Mr. Harmanlang. Is there an affidavit?
Lordship. Lordship, next 2. In my counter.
Why was that recorrected after on behalf number 7?
Lordship, as per my thing, the respondent number 2 had the
show the annexure. Which affidavit, Mr. Karmanlan?
My counter affidavit, Lordship.
Which one? Which respondent? There's one by 7. There's one by 3.
Lordship.
Then see it, no?
My apologies, Lordship.
No need to apologize. Be clear what you have to say. That's all. Submission should
we had
be
sent this.
Logical, yes. 8/7/2010. Where's that one?
Lordship, page number 9.
Page number 9. Okay. So it's not even 1100 like you were given when you appointed. It was yes, 11,300 in the same.
Appointment was in
right. Yes, Mr. Kongnoka, continue.
Yes, Lordship, after this impeachment order, then we are bound to approach this honorable court, Lordship. My humble submission is that, Lordship, there's no error from the petitioner's side when she applied for the post, as it was advertised. So she has applied, she got the job, and then later on they have changed the scale of pay.
Yes.
So
the question of recovery should not be there. Because not due to your fault.
No, it's
or
not my
to any
fault.
fraudulent act or malefied act.
No fault at all from the petitioner's side, Lordship. And then it's the respondent who have changed this pay of scale, Lordship. Lordship, in this regard, Lordship, I rely upon this AIR 2015. Paragraph 58, Lordship, page 700.
Paragraph
58.
58.
Page 700, Lordship.
58. This is this page 700 is this is para 11.
Lordship, before that, please.
Para 11 refers to para 58 of the judgment on Abdul Qadir. Yes.
Lordship, before that, please come to page 696 in this citation, Lordship.
Yeah.
Excess payment. Excess payment of emolument recovered from employee not impermissible only because employee has paid no role in wrong payment made by the employer, but exercise of employer's right of recovery would be improper and has to be denied when hardship caused to employee for outweighed right to to recover. Lordship, and this, it has been going on for more than 5 years, Lordship.
That means you have paid from, wait 1 second, 26/8/2013 to 25. Yes, 9. More than 5 years, yes.
Lordship, it'll be very difficult for the petitioner to, to refund this
Have you
amount.
started deducting from your pay now?
Why not?
Have you started recovering from your pay or no?
No, they have not started. After we filed this petition, they have not started, Lordship. And it'll be very difficult for her, as, she depends on the salary itself. So to feed her, her family.
That is a given.
So
yes, Mr. Karwanlang, what do you have to say?
So my humble prayer is that, Lordship, to direct the respondent not to recover this excess amount, Lordship, because it's not her fault.
Now from 18 you've been paid that lower scale.
No, Lordship.
No, now after 18 you're being paid this 11,300 scale now.
No, Lordship, we are still paying this.
You're still paying the old scale of 14.
14,000.
Why? There's the order.
Some sort of order is there.
No, when was this file? 19. Where's the order sheet? Oh yes. So 26/4/19 been stayed.
Lordship, henceforth adjustment maybe made.
Only refunds been stayed, but then the payments have been stayed. See, the payment at the refix scales have been stayed. Only that impugned letter asking for a refund for the amounts you drew, like excess from 2013 to 18, that has been stayed.
Yes, Lordship.
And still they're paying that old amount.
They're still paying that big amount.
Why?
Lordship, I'm not aware about that.
Not aware about that. That means that you're putting additional burden on the petitioner. If the order only says stay, then if you pay at the new scale, you pay the new scale. That refund amount for recovery, that's a different aspect altogether.
Lordship, I've informed the department regarding the stay of the recovery, but not regarding the payment. But Lordship, if I may.
Yes, please. What do you have to say?
Lordship, as I may recall, Lordship, we had if I may take your Lordship to the Meghalaya Service Pension Rules. Lordship, as per Rule 73, Lordship.
Well, you already retired now?
No, Lordship. But then these rules provide that recovery may be taken from the petitioner, and this also as per the Treasury.
Articulate submissions well. What do you want to say? What do you want to show?
That recoveries can be made from the excess payment.
Show that. But there's certain other aspects which you look into. What is the culpability of the writ petitioner in excess amount being given?
I satisfy my Lordship on that issue. Lordship, if I take my Lordship to the judgment date in 2012, 8 SAC 417.
Show that, yes.
Lordship Chandi Prasad.
Reported in
2012, 8 SAC 417.
Yes.
May I take Lordship to paragraph 14? May I read, Lordship?
14.
14.
Yes.
We are concerned with the excess payment of public money, which is often described as taxpayers' money, which belongs neither to the officers who have effected overpayment nor the recipients. We fail to see why the concept of fraud or misrepresentation is being brought in such situations. The question to be asked is whether excess money has been paid or not. May be due to bona fide mistake. Possibly effecting excess payment of public money by the government officers may be due to various reasons like negligence, carelessness, collusion, favoritism, etc. Because money in such situations does not belong to the payer or the payee. Situations may also arise where both the payer and the payee are at fault. then the mistake is mutual. Payments are being effected in many situations without any authority or law, and payments have been received by the recipients also without any authority of law. Any amount paid received without the authority of law can always be recovered, barring few exceptions of extreme hardships, but not as matter of right. In such situations, law implies an obligation of the payee to repay the money, otherwise it would amount to unjust enrichment. Lordship, in this case, it's admitted that there was overpayment. There was
Take out the Abdul Qadir case where they've said exceptions are there.
Exceptions.
Show that case. Where's that case? Have you brought the Abdul Qadir case?
Lordship.
What's citation Abdul Qadir?
The 2014 ACC.
No, that is 2009. Show that 2009 judgment. Okay, I think the instances have been laid down there.
2009 judgment.
Yeah, 2009 judgment.
No, Lordship.
Why?
But
you're a young, smart counsel.
Lordship, but then, Lordship, also I would take my Lordship to the 2014 ACC 883 Lordship, which so Lordship, the Rafiq Masi was later referred to a larger bench, a 3-judge bench. If I remind my Lordship, there was a matter which I had done earlier regarding where
before this court.
Yes, Lordship.
Rafiq Masi.
Yes, Lordship. Yeah. So the 2-judge bench had referred.
Yes.
Where Lordship, the court has stated that the High Court in several instances.
Where is the judgment of this court?
Which court? The Supreme Court Lordship had, in several instances, has stated that recovery can be made in occasions where there are hardships and the fall of the government. But then, in this instant case, Lordship, it has been done as per law.
No appeal is carried from this order.
Pardon, Lordship?
No appeal is carried from this order.
No.
There's no appeal. See, in this case, it was totally different because at that point of time, when this petitioner in this case was afforded that other scale, there was an undertaking given also that in the event that there is, overdrawn, then that money will be refunded. That's one aspect. And the other aspect is that Rule 73 of the civil pension rules, which allows for recovery. Okay.
Lordship.
So those are two things that stood in the way of this petitioner at that point of time. Now, maybe this judgment will be applicable to him now.
Pardon, Lordship.
Maybe Rafiq Masi we can take shelter of Rafiq Masi. Yes or no?
Lordship, but Lordship, what question I pose to myself, Lordship, won't that be unjust enrichment? And also in the petition, Lordship, has the petitioner shown any hardships which was caused to her?
It's a big burden on her, Lordship. After a gap of 10 years now.
Lordship, this correction was made after 1 year, after her appointment, Lordship. After a period of 1 year, Lordship, how much hardship can there be?
After?
A period of 1 year that was given to.
Why did you continue paying the person at the scale after 18 also?
Lordship, I have to
there's not
seek
a 5 years.
I have to seek instructions regarding that issue, Lordship.
To prepare, there's another case, Thomas. You prepare your matters, you can articulate your arguments well.
Lordship.
Okay. Okay, Mr. H. Warandang seeks time to prepare the matter and to seek for the instructions. List after 1 week.
Lordship.
Good.
17.
All right, Mr. Nofal. You also have not shown any hardship, anything, because, and also Rafiq Masi, you see, is a judgment which is, I think, under 142, which, will not form a precedent.
Lordship.
Is the thing. If I'm not wrong, go.
I'll try to satisfy my Lordship.
Yes.
Much obliged.
17.
Just give me 5 minutes. Yes.
This is the second appeal in which Your Lordship had framed the questions of law.
What a question of law. Is metal still surviving? I thought it had been disposed of.
This appeal was 2019.
But second appeal 2020 isn't here?
20? Yes, I mean, it was registered as a second appeal in the first part of 2020.
Questions of law, Your Lordship will see the order dated 22/4.
22/4 of?
2022. The appellants have submitted suggested 6 substantial questions of law, of which this court has accepted all except number 2. Because since there were no pleadings even before the trial court or the appellate court.
That is whether the appellant can be made to suffer.
Yes.
That is out.
That was out.
Yes. So now only that whether instant appeal under 226 lies against impugn order, whether the admitted signs actually bear on the suit. Yes. 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 Yes.
Well.
And from your substantial questions of law?
Yes.
They've been accepted also?
No.
No.
There's no order to that effect, but we have filed. One is that whether incorrect statements have been made by the appellant in his application for condonation of delay, because this is the crux of the matter.
Then, Mr. Chowdhury, I think we should include this also as another question.
Well, what I would submit...
Will it not cover in the other this?
Well, what I would submit, Miller, if I can take Your Lordship through the impugned order, and after that Your Lordship can modify the questions of law. Suggested questions are before Your Lordship.
No, because once suggested issues are there, then we suggested question we have to answer the appeal in terms of those questions that have been framed.
Yes, but
we'll do one thing. We'll just recast it, like we just go back to the order and we'll include this question, and make a, because in fact there's no consolidated has been made as yet.
Right.
That should be made, by the court. Okay.
That is of course. That would make it convenient.
Yeah, that'll make it convenient. What about number 2?
Number 2 also.
Number 2 of...
where there's essentially a finding of fact by both the trial court and the appellate court. And whether this court, second appeal...
Okay. Take down. We'll have another day.
Well.
Yes, it appears that due to oversight, when the substantial questions of law were framed by order dated 24/4/2022. 22/4/2022. Only the questions which had been submitted by the appellant had been taken into consideration. Stop. Today, at the time of hearing, Mr. T.T. Tingdol and the Senior Counsel has also referred to the questions which had been submitted by the respondents, and submits that the same also are relevant for consideration. Next paragraph. Mr. S. Chakravarti, the Senior Counsel with the appellant, has no objections if these questions also incorporated for adjudication, along with the early accepted substantial question of law. Accordingly, the questions of law that will be gone into in the disposal of the appeal will be the questions number 1, 3, 4, 5, and 6 submitted by the appellant, and 1, 2, and 3 by the respondents. Consolidated list to be prepared by the counsel. Be prepared. We'll prepare ourselves. That matter come for hearing on
In June, will not?
It'll have to come in June, yes, because I will not be here.
Sometime in what?
June 19th. No, June 18th. No, June is 19th.
19th.
Sorry, it's a fault of the court.
No, our fault also.
No, yes, I mean, it was not shown. That's why, yes. Because usually sometimes we take both of them, we compare them, and then we distill the ones that, actually court also frames as own. But I've taken. Anyway.
No, we'll prepare a compilation of the orders and all that.
21?
Well,
21?
May I please, Your Lordship? Your Lordship, the respondents have already filed the affidavit regarding the instruction. But Your Lordship, after perusal of the affidavit, it's almost the same as what they have stated in the counter affidavit and their additional affidavit stating that the petitioner is not entitled to receive the nursing allowance. But here, Your Lordship, the petitioner was remustered into the post, retrospective effect. That is from with effect from 16/1/2002.
When the rule is still applicable.
Yes, Your Lordship. And Your Lordship,
that's why I filed an affidavit. I don't know, take your own verbal ballot.
But Your Lordship.
Let's see the affidavit. That's or not.
Page 2 of the affidavit filed on 28th April, my lord. Page 2, last sentence, my lord.
Page 2, filed on 28th April.
Yes. On page 2, the last two sentences, my lord.
But the notification.
The petitioner has been remustered as a rifleman retrospectively with effect from 16/1/2002 by the order dated 23/1/2020. That is on the date when payment of nursing allowance already discontinued. Hence, the petitioner has not been paid in nursing allowance for the period from 1897. Page 2, last two sentences, my lord.
The petitioner.
That is their affidavit filed on 28th April.
So basically, it says, my lord, he was remustered as nursing assistant, my lord, with effect from 2002.
What about 1907 to 2009?
So, my lord, he will be, in my understanding, he will be entitled from 16/1/2002 to
till 2019 when the
till 2019.
2019 or 2020?
2019.
2019 when the allowance was discontinued, Your Lordship.
When is it discontinued? Exact date?
30/6/19.
2019. In fact, that was because there was a case pending also, Your Lordship, for the remonstration.
So he'll be paid 17 years.
Yes, Your Lordship.
Okay.
There may be some discrepancy in the dates, my lord.
To verify them, because the order comes.
If lordships, without mentioning the date, if says that for the period when this was paid to the others, it should be paid.
Wait, what do you mean by when the amount was paid to the others? Again, you're opening the door for reinterpretation and for fresh petitions.
No, my lord, why I am saying, my lord, because here in what para 3 itself it says that, however, payment of nursing allowance to nursing assistants of Assam Rifles was discontinued with effect from 1/9/2019, as per the directions of the Ministry of Home Affairs.
Where is that in your own last affidavit?
Yes, my lord, same affidavit, my lord. In para 3, my lord, 5th line, my lord. However, payment of nursing allowance to nursing assistant of Assam Rifles discontinued with effect from 1/9/19 as per the directions of the Ministry of Home Affairs, Government of India, so and so, 17/12/12, and as they were not found registered with the Indian Nursing Council or State Nursing Council.
Yes.
Then it says, my lord, the petitioner has been remustered as rifleman with effect from 16/1/2002 by order dated 23/1/2020. That is on the date when payment of nursing allowance was already discontinued. Hence, the petitioner has not been paid in nursing allowance for the period from 1897. 1897 will not be entitled because you registered only from 16/1/2002.
No, but for the respective, there'll be entitlements will be there.
Yes, my lord.
That's all.
From the date of his remonstration, that is from 2002 till
Yes.
till it was paid to in
Yes.
the year 2019.
Take down, you correct me as I go along. I'll dictate the order.
Well, the dates itself are in the affidavit itself not correct. My lord.
Not correct. Yes. How many petitions are there? Only one.
Only one.
Only
Your
one.
The writ petitioner who is presently serving as
Nursing assistant.
rifleman,
RFN.
RFN, bracket nursing assistant, is before this court with a prayer for release of the allowances which were admissible from the date of his remusteration from the post of rifleman, bracket general duty, to the post of rifleman, bracket nursing assistant, from 16/1/2022. We won't allow any interest, but 2002. Won't allow any interest.
Interest will be difficult. Interest will be difficult.
We'll give interest.
If
Interest should
can
be given.
considered, Your Lordship, because we have been filing.
We'll give notional interest 6%.
But he also came to court very late.
Yes, came to court very late.
No, actually, we have been.
21 you came anyway.
No, Your Lordship, we
Yes.
have been filing the writ petition since 2013, if I'm not mistaken, Your Lordship.
Nursing allowance as admissible. Stop. MS Karsono, AP Karsono, for the writ petitioner submits that the entitlement of the petitioner cannot be denied, inasmuch as though remonstration was effected on 23/1/2020, the same was with retrospective effect from 16/1/2002, when the scheme of payment of nursing allowance to nursing assistants of Assam Rifles was still in operation, which however came to be discontinued from 1/9/2019 as per the directions of the Ministry of Home Affairs. Stop. She further submits that the denial of this allowance to the petitioner, which is his just entitlement, is arbitrary and has caused financial loss to the has caused financial loss to Dr. N. Mozikar, Leonard, DSGI, assisted by so and so, submits that the nursing allowance to the nursing assistants of the force had been introduced with effect from 1/8/1997, but however, as these nursing assistants were found to be not registered with the Indian Nursing Council or State Nursing Council, the said allowance to such nursing assistants was discontinued by the respondents from 1/9/2019. So, he, however, concedes to the fact that whatever retrospective entitlements the petitioner, whatever respective benefits that the petitioner is entitled to, the respondents, that what he shall be applicable for the period when the said scheme was still in operation. The senior counsel also drawn the attention of this court to the affidavit filed, wherein these facts have been narrated on affidavit. Have been narrated. Stop. Para 3, which is relevant for the purpose of this case, for easy reference, is reproduced here and below. Next paragraph. Having heard the accounts for the parties, the short point for adjudication in the present case is only to the entitlement of the petitioner for the period from which he had been remustered as rifleman nursing till the date when the said allowance was discontinued. Stop. It is not disputed that the petitioner had been remustered as rifleman nursing assistant retrospectively with effect from 16/1/2002, White order dated 23/1/2022, the date on which the payment of nursing allowance had already been discontinued. Stop. However, for the dates on which the petitioner has been respectively remustered and when the nursing payment nursing allowance was allowed, it is undeniable that he is entitled to the same. Stop. Next paragraph. In view of the facts and circumstances of the case, it is directed, the respondent directed to pay the nursing allowance to the petitioner from the date of the respective remuneration or remuneration, that is 16/1/2002, till the date, till 36/2019, when the said pay allowance was discontinued. What about interest?
My lord, in my submission, interest, because they have approached this only in 2021, my lord.
But that, your lordship, we have filed petitions after petitions only for that, your lordship, for remonstration first, and then they themselves.
Remonstration is different. Now this is different.
Your lordship, but allowances also was included in that. Your lordship, if little bit.
Looking into the last.
And if I may, your lordship.
That is 16. Stop. The petitioner shall also be entitled to. He came 2021.
2021, your lordship, because we were waiting for that also.
So then we'll give you 3% interest.
My lord, though I do not have a citation, my lord, but in such cases, at the most for the limitation period of 3 years, my lord, from the date of filing, not beyond that, my lord.
Remastered 2002.
The order was on
Came to court in 21, my
2020.
lord, at the most for 3 years. In my humble submission, they're getting substantial relief, my lord.
For 3 years only. We'll give them for 3 years interest from 2002 to 2005.
But we
No,
were
madam,
waiting
last
for
3 years,
the
madam.
we were waiting for the department, your lordship, to
Yes.
take that
No,
initiative.
this 3 years or 5 years, interest, many decisions are there. Stop, last line. Stop. In further consideration, the petitioners shall also be awarded interest at the rate of 6% for the last 3 years.
From the date of filing of that.
Huh?
From 21.
From the date of filing the petition till the amount is. If you say last 3 years for the date of filing, it means they'll get for entire amount. For last 3 years means you have to make it clear. Last 3 years before the
2018 onwards.
Yeah, from 2017. For last 3 years before the scheme was continued till the final payment is made.
Your lordship.
Calculation of interest will be subjected to many
But
interpretations.
at least a minimum time frame, your lordship.
It's expected the entire exercise to complete within a period of 4 months from the date of presentation of the order before the respondent.
Your lordship.
Yes.
For the interest calculation, I still think, well,
6 into 3 years for the last 3 years. 3 years means 17, 18, 19.
came to court in 21, my lord.
Doesn't matter.
But 2020 order is also there. It's their own order.
Implementing the calculating interest.
When you come out of formula, this court's not good in this number crunching.
Highly obliged.
No, when you just come up with something, we'll correct the order. Just sit down and yeah.
Highly obliged.
Highly.
Yes, Mr. Ready?
No, my senior counsel is engaged with one arbitration matter in commercial court. He was here.
Don't make those excuses. It's a personal difficulty. Commercial court not takes position of the High Court. Yes.
My apology. After we.
No objection. No urgency.
Urgency, that's a casual,
Then?
casual.
This is for those
regularization, my lord.
NIPCO.
NIPCO.
Yes, mention be made on senior. We have a senior counsel, Mr. Vikshindal, stated we are not available in court presently. This after
1 week.
1 week. 2 weeks.
No, my lord.
1 week.
It's
What about that matter? Excuse me. Yes.
My apology, my lord. It seems that copies were served, my lord.
That is why I wanted you to
Not
verify.
shown to me, my lord.
Yeah, what is the matter about?
WPC number 104 of 2023.
Yes, yes.
In this petitioner, in this case, the petitioner is a contractor.
Is a?
Is a contractor of various materials to the respondent and other government authorities, Your Honor. My lordship. That the respondent number 1 invited tender on dated 2nd November 2022.
One?
2nd November 2022. And which is the annexure 1, the NIT.
20?
22.
Okay. Page
20 onwards, lordship.
Okay.
Annexure 1, page 20 onwards. The petitioner and the respondent number 3 participated in that by submitting their bids, and in conformity with the tender document, the petitioner submitted all the documents by uploading the same in the designated.
It's a contract for what? Supplier?
Supply of fresh vegetables and so. Lordship, and thereafter, but the respondent number 3 did not upload all the required documents.
Who is respondent number 3?
Respondent number 3 is another contractor from Guwahati.
Yes, okay.
Wasis Enterprise.
Yes.
And in these circumstances, the petitioner submitted a representation.
But you have submitted everything.
A representation.
Yes.
A representation attracting attention of the respondents, the respondent number 1 and 2, that this has not been done. But my representation has been disallowed. And that is the impugned order, which is annexed as Annexure 6 in page number 149. Against that impugned order, we have come before the Honorable Court with prayer that in the premises as aforesaid, it is most respectfully prayed that your Lordship may be graciously pleased to issue rule. Call for the record that after hearing the parties be pleased to issue notice upon the respondent number 1 and 2 to cause as to why writ in the nature of mandamus and or any other writ of the like nature.
What are you reading? What are you reading?
The prayer.
You make submissions. Why are you reading the prayer?
My lord.
Now you say that read the impugned order.
Yes.
Yes. There's no irregularity seen in the tendering process. In case you have any other verifiable points, the same can be shared. It's closed. So.
Yes. Yes. It is closed.
Yes.
But that was without giving us any opportunity.
What are the documents did not upload?
Yes.
Have you made
yes. That is in page number 21 of 21.
Where are your pleadings? In your pleadings?
In your pleadings. Yeah.
Where are you from?
I'm from Silchar, my lord. My lordship, page number 6, page number 6, paragraph 3. The submission of tender forms was mandated to be online in accordance with the tender forms of Directorate General of Assam Rifles made available at www.eprocuredgovernment.in, accompanied by scanned copy of proof of the earnest money deposit in the prescribed format enclosed to the bid document. The clause to file the bid document provides that e-tender to be received in electronic form, and all bidders were directed to submit documents in a two-bid system, that is the technical bid and the cost bid. Clause 6 of the bid document prescribed the necessary documents to accompany the technical bid, and it is provided that all tenders bidders, including existing contractor, must upload the documents, providing that if the tender is submitted as part of the PQC, and that the document prescribed to A to L to be submitted.
Where's the violation, you say?
Yes, I am coming to page number 21, my lordship.
No. Where do you see that? Where do you make a vermin in your petition that these were required 1, 2, 3, 4, and it was not submitted by respondent number 3?
This is. That is paragraph number 5.
Okay, 5.
Page number 8.
That's one by the tender, so and so and so. The technical bid was defined in
technical bid has been defined in clause 6, and the document providing that all the contractors must upload the documents duly scanned website without.
Where you said that the respondent number 3 has not done it?
Yes, it is written.
Where?
Yes, paragraph 8, page number 10.
Okay.
That the respondent number 3 also responded and submitted his tender, uploaded the documents in support of this. But while uploading the documents, the respondent number 3 did not disclose the following work with the ITBP. That is ITBP HQ Tejpur 55 BT items combined. ITBP Hakalpur 54th BN combined. ITBP 10th BN IT items combined. This is where the skipped.
These are three things only.
Three things.
So do you mean that the non-submission of these other works?
Yes.
So that means is a serious defect.
Yes.
That the tender has become defective.
Defective, and that is provided in the
21.
document itself.
Let's
be pleased to peruse the page number 21
yes.
of Annexure 1.
Yes.
Clause 6. Technical bid. All bidders including existing contracts must upload the following documents duly scanned.
Where is that? Clause 6.
Clause 6.
All tender documents. Okay. Where is that says past experience?
Yes. And that is in page number 22, Lordship. Clause 6E.
Yes.
Details of existing contracts and tender participation. Bidders will submit details of existing contracts for the financial year 2022-23 and tenders participation
yes.
for the then Lordship, the note appended to clause 6 in page number 24. First note is that all documents mentioned in para 6b to 6m above are to be uploaded duly scanned after signing the documents by all bidders concerned to avoid rejection of tenders. That
so how do you know that they did not upload this?
Yeah, because these are some online.
You've seen that?
Yes.
Then the order says that
we have submitted all the documents.
No, they said that.
For the purpose of transparency, Lordship, nowadays all the tenders are submission of tenders.
Yes, Mr. Dr. Mazika, yes.
I'll require instruction. My lord, since it's Supreme Court stay, my lord, if 2 days time is given, my lord, by Monday or Tuesday, my lord, I can have instruction.
Lordship, maybe some kind of stay will be given, because if once it is opened, the price.
When's going to be opened?
They are planning to open it on Monday. Open it on Monday.
But is it will disable the tendering process? Have you examined the clause?
Somehow it is the file income, my lord. I'll have instructions. I'll talk to them today itself, my lord. If there is any plan to open
we'll list on Monday.
Can we list on Monday?
Heard Mr.
S. Chaudhary.
S. Chaudhary, Land Council petitioner, issue notice. Dr. N. Mozika, Leonard DSGI with so-and-so is present on behalf of the respondents 1 and 2. No further notice, no call for respect respondents. Stop. Before issuing notice to respond number 3, Leonard DSGI is directed to obtain instructions by Monday itself. List the matter on Monday.
Instead of Monday, it can be Tuesday, my lord. Because of the weekend.
By Monday, list the matter on Tuesday.
Tuesday.
Yes. As in a motion, yes.
On the previous matter, the judge.
Yes.
But Ms. Kharsona is not there, my lord. But this would be.
You've shown her. You kindly show her, then send it to give to the PS after that. You kindly show it to her first.